Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Bryan Vix, Cooper's attorney extraordinaire, we will be discussing how answering discovery helps one gain greater appreciation of a case, as well as tips for streamlining the process. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Bryan, welcome to the show.
Thank you for having me. I appreciate being here.
Today, we're going to talk a little bit about discovery and primarily how to engage in responding to discovery, which is one of the first things one has to do when a case gets filed.
The joyous part of litigation.
I know you were saying that with a little bit of, I'll go so far as sarcasm.
I think that discovery is something that a lot of lawyers do not look forward to. It is a thorn in their side sometimes.
Agreed. I think that the process of taking all of the information that one has in a case and delivering it to the other side can feel tedious at points, and yet at the same time is essential to helping the other side understand their exposure and the risks in the case.
Agreed.
In terms of a starting point, in your practice, places you've worked, have you worked with a confidential client questionnaire?
I have, yes.
Can you expand on what that is?
Confidential client questionnaire will be a document that we typically give at intake or go over on the phone with the client or the potential new client. And we get some of their background information, some of the information relating to the case, the claim, how we would proceed forward with the case.
One of the things I learned early on at a firm is if one takes the form interrogatories, the standard set of questions, and uses those as a roadmap for the client questionnaire, then it's pretty easy for that to be a cut and paste operation to take the information from the client questionnaire into the form interrogatory responses.
I would agree. I think that the form interrogatory questions end up being a very good roadmap for a client questionnaire at the beginning and the onset.
And I'm going to go back to the idea of responding to discovery. Part of the process of learning a case involves kind of getting into the granularity. And in terms of your role within the firm, is that fair?
Very fair.
And on that granular side, do you find it helpful to go through this to get a better sense of what's going on with the client and the minutia of the injury and the treatment?
I think that doing discovery responses, answering discovery questions is probably the single most important background familiarizing yourself with a case that you can do as an attorney, maybe other than reviewing a medical record summary.
Understood. And we're diverting a little bit off the discovery side. The medical record summary, why is that important to you?
It will give you a better understanding of the client's medical condition, treatments, issues that they've had, reoccurring themes, where they've gone to treatment, essentially how much their treatment cost, which would essentially be included in your discovery responses, and gives you an understanding of what they have gone through, how they have been injured, and any long-term lasting effects that their injuries have affected them with.
So going back to the confidential client questionnaire and then the discovery, once the pile of discovery, and I refer to it as a pile because standard situation is we file a complaint, the defense serves an answer, and right along with that answer is a nice fat packet of document requests, questions, interrogatories, sometimes requests for admissions, oftentimes a deposition notice. When that packet arrives, how do you approach it initially?
It depends how prepared I am. If I did the intake myself, if I'm pretty familiar with the client, if I know how the client questionnaire is, I'm going to be a lot more confident at the start because I know that I have all the background information. Depends on how many defendants there are and how many sets of discovery there are going to be. And it depends on how familiar, before I'm touching anything else, I'm familiar with the documents. Do we have all the documents? Do I have all the medical records? Am I going to have to be calling and hounding release of information offices trying to get documents that I know I'm going to have to produce.
Understood. With that as a backdrop, at the outset, do you ever recognize, look, this is going to take longer than the 35 days that I have to respond to this? I just know it, given where things are. Do you ever proactively reach out at the beginning to call up defense counsel and say, hey, I got all this, appreciate it, going to get you all the information, I'm going to need a little bit more time?
I try to hold off on that a little bit, but it's not something that's uncommon. And in all of the discovery responses and practice that I've had, discovery extensions are a common trend and a common theme that happens, and a common courtesy that attorneys give each other back and forth, understanding that we have a statutory obligation to respond in a certain amount of days. And oftentimes there are outside things that affect us being able to get that done within that time frame.
Well, 35 days sounds like a fairly lengthy amount of time. And the example I always use is 45 days to build a Liberty ship, which we used to send troops across to Europe during World War II. So 35 days, you should be able to answer some questions for the other side. However, when you think about those coming in, when you think about templates being built for the answers, if you're going to try and make it as easy as possible for the client so that they don't have to put more information in, and you move the information from the client questionnaire into the template, all of that preloading means you've already eaten several days to a week before you even get the information to the client to review. That's why I ask about extensions and other pieces.
Well, also, don't forget, you're a working attorney. You are going to have more than one set of discovery probably sitting on your desk. You are also going to have other obligations for other cases that you have as well that you are going to have to manage. And you're not going to have 8 hours in a day just to respond to one set of discovery too.
On the template side, how have you approached the template? And by templates, I mean, in a perfect world, as far as I'm concerned, I like to have the question in a document followed by the answer, meaning we are, in essence, cutting and pasting all of the questions into our response so that one's not having to flip back and forth to the request for admission to see what the request was and then flip to another document to see the answer. On the templating side, are there techniques that you use, whether it's with staff or contacting opposing counsel to see if they'll send over a Word version to get those templates?
So I have worked at offices where it's been done both. I have seen the questions presented first and then we respond. And I do think that in practice, that's probably the best way of doing it. That way it's one document that you can refer to versus having to go back and forth. If you ever are in a deposition, you need to use it as an exhibit, or if you're ever in trial, you need to use it as an exhibit. There's one document versus having to use two. Typically speaking, I started as a paralegal and I'm pretty familiar with having to format discovery responses and then moving over as an attorney, answering them as well. And I've seen it done both ways where you will use OCR programming to copy and paste them, go back and make sure that they're worded correctly and that they're formatted correctly. I have seen some attorneys give you a courtesy of giving you a Word document so that you can copy and paste them over. And I've also had to do the old school, old fashioned way of having to just type it out as well because OCR wasn't available at the time. I think that the easiest way of doing it is just to be given a courtesy copy. I don't go out of my way to ask it. I find that it's easier for me to OCR it and copy and paste it and make the formatting edits faster than I would probably get a response.
That makes sense. Tangent, but worth asking. In terms of having been a paralegal and now having been an attorney, any lessons that you would like attorneys who are listening to this to know about things that make life as a paralegal easier? Top 2 or 3.
That's a very loaded question. Understand that your paralegal is juggling a lot, and understand that they might wake up in the morning and they might have a laundry list of things that they know that they need to get done and moved across your desk. And in the myriad of the day, they're getting 15, 20,000 emails, and they're going to have to readjust their list to accommodate you and make sure that you get the documents that you need. And that is their number one priority. And a good paralegal is going to move mountains for you. So the second thing would be treat your paralegals well, because they are the make or the break of an office. There used to be a sign that I used to have, and it was if you want to know what's going to happen with your case, ask the paralegal, don't ask the attorney. Sometimes attorneys are managing too many cases and they might not know the minute details of a case. A paralegal at the onset is going to know all the minute details. Third thing, have a good relationship with them. You obviously be professional, but I think that there is a very clear-cut opportunity for attorneys to have a good relationship with the paralegal where, yes, it is, attorney and paralegal, but at the same time, you also can have a good relationship where they start to learn what you look for in a document and take the time to go over those things with them. It'll make their job easier. They'll know what you're looking for. They'll be able to cater your documents how you want them.
Those are great points. Thank you. The piece I would add, this is sort of a question, is have you had experiences where attorneys or a firm treats it in a hierarchical fashion as opposed to a team fashion?
Yes.
How have those worked out?
Not well.
That's what I thought. Going back to the discovery itself, once you've got the templates built out, what's your next approach?
The first thing that I'm going to do is I'm going to look at the production of documents requests. And that's normally because what I find is that production of documents is going to be the time gate for anything. And that's largely because in that production of documents request, it's going to ask for copies of bills and medical records. And at the onset of the case, if I have all the medical bills and I have all the medical records, I'm sitting hunky-dory. If I'm in the middle of a case and I don't have them, I'm going to be scrambling, sending out requests, calling, following up, having to pay for records, having to try and get all those records expedited. So that will be the first thing that I'll probably look for. What's the production of documents request look like? How beefy is it? And then after that, I'm going to look at my records and see what I'm going to have. The next step after that is I'm going to go and look at the other interrogatories because they have a statutory limit on how many they can ask. And I would just make sure that 1, they're within their limits. 2, if they are not within their limits, they have the accompanying declaration that they need to put. 3, if they're not with a declaration, I'm going to reach out to the opposing attorney and say, hey, you sent me 45 special interrogatories. Was this on accident? Did you happen to forget your deck? And I'm going to extend a courtesy at the onset for them to fix the deficiency in the discovery request.
That makes a lot of sense. And I've worked with various attorneys over the years, and there are attorneys who are hard-nosed about the deck for additional discovery or, for example, obvious typos in questions. And I've seen lawyers who will reject those out of hand. They'll use the 35 days and take joy in sending back in essence, an FU. I've also worked with attorneys who will treat those as you described. It looks like you might have forgotten a declaration, or you're referencing 2037. Do you mean 2017? Because that's when the incident happened. Have you seen how those different ways have played out in cases? And do you have an opinion as to how to approach things?
I have never seen a situation where me creating a roadblock at the onset of a case, knowing that I'm eventually going to have to answer these questions no matter what, has benefited me. If anything, it creates hostility at the onset. And I would give it an example of starting off a relationship on a bad foot. When you start dating somebody, things are supposed to be going great. They're supposed to be easy. At the onset of a case, yes, you can have some adversarial processes, but you don't need to be creating unintentional adversarial processes at the start of something. You can have some civility, have some discourse, and create this image to the opposing counsel that you're willing to work with them to move this case along. You have your ethical obligations and duties, and you are going to advocate for your client, but you can also do so in a respectful way. This is a profession, and it's our job to elevate the profession. We're held to a higher standard in society, and we should reflect that while we're talking and treating each other that way.
All of those are great reasons to do it that way. An additional one that is far more bottom line, I guess would be the way to put it. John Holverson, one of our firm's founders, has used the phrase, don't piss off the banker. That, in essence, until you get to a jury, it is the adjuster and the defense lawyer who are the gatekeeper for getting the case resolved. And if you don't give them the information, if you don't collaborate with them to help them understand the exposure, you're doing yourself and a client a disservice.
That's a good way of looking at it from someone who's got a lot more experience than me. And that's something that I've never really kind of thought about until it was phrased that way. So good for me to listen to.
just to give that some more credence, Hoverson will say that's not his, he came from a firm from St. Louis where his grandfather started the firm, his father was part of the firm, and he's got a long legacy of plaintiffs' lawyers to help us understand why that's important. I took us down a tangent, and we were at document responses, I believe. And maybe I'm getting too far ahead of myself, but do you have a theory and methodology for bait stamping?
Again, it kind of really depends on how big the file is, how many documents am I going to do. I'm a really big, keen advocate for organization. And when it comes to records and production of documents, I try to be very meticulous about how my records are organized. I do pity any paralegal that has to work with me on medical records because I definitely have a particular way that I want it done. And what I would say is bait stamping can be beneficial. I find that I have more of a Word document that I'll have everything listed out, particularly dealing with records, what I'm dealing with and where it's coming from. And then I would put it into an exhibit, and maybe I would probably bait stamp it if it was a big file. I think it's just more of a case-by-case situation.
Well, we're on the theory and methodology. What is your approach to objections in discovery?
In one regard, you need to make objections that you need to make. In another regard, there are going to be questions where you can make an objection. However, this information is going to come out, or this information is clearly relevant, and the objection is just a formality, or you're doing it to add lip service to the objection. I find that making unnecessary objections gives you less credibility with the opposing counsel, as well as it probably makes the document look a little bloated. It just seems like it's unnecessary work. Sometimes, again, you can make an objection, but this information is going to come out. This is the onset of discovery. If something is unfavorable, I have the tendency to believe that it's better to get some unfavorable fact out in front and start dealing with it on day one versus trying to hide the ball or not disclose it, hide behind an objection, only for it to come out later on when you really kind of deep down in your gut knew it was going to come out.
That makes a lot of sense. I will add from the trial perspective that one of the issues plaintiffs' lawyers have is they step into the courtroom with the least amount of credibility of anyone there. The jurors have been preconditioned through decades of advertising by insurance companies to think that we are slick, lying, cheating people who are just out there to get money. And one of the ways that we try to approach that is by making sure that we are not hiding the ball, that we are direct, that we answer questions, and that we provide the information. And when a discovery response gets read with 4 paragraphs of objections before there is an answer, that has a tendency to undermine the efforts to do that. So we talked about objections. In terms of the documents themselves, how do you review the documents to make sure that the information in there is not problematic in any way? And by problematic, I don't mean negative. I mean social security numbers or other things that might be subject to redaction.
I think that is something that is often overlooked and something that I try to pay particularly close attention to as a paralegal is when I'm reviewing documents before they're being sent out. For example, if I'm objecting in a form interrogatory question regarding the social security number, it doesn't make much sense for me to object and not disclose a social security number, only to then disclose medical records, which has a patient profile information on the front page that includes their social security number. So it takes some time. You do need to go through the documents, review the documents, and you do need to make your redactions. And if there are a lot of redactions, I oftentimes will also give a heads up to the opposing counsel and say, hey, I'm producing all of this. There are redactions. The redactions are relating to information that 1, is not relevant, 2, I objected to, and just do a cordial courtesy. I've never, ever gotten any pushback from that, knowing later on down the road that they would be subpoenaing these records as well anyways. And oftentimes they appreciate it and they say thank you.
That makes a lot of sense. What about things, and every now and then you'll end up with a medical record set where there is a reference to some minor non-case related issue. And primary care physician's records are obtained, and there's a reference to a mole being removed for someone who's got a knee issue. Do you always suppress that record, or do you sometimes let it go depending on how it impacts the case?
If it does not impact the case, I would, one, talk to the client and I would just confirm that, hey, you went to this facility for X, Y, and Z treatments, X, Y, and Z days. Is there anything that I should be concerned about? Then I think about it. And then I would probably, as long as there's nothing that was going to come up and surprise me, I would probably disclose it. I end up seeing that shows me in a more favorable light with the opposing counsel. I'm not hiding the ball. Hey, this isn't relevant, but it's no sweat off my back to disclose this to you either. And the client's not afraid of it, and the client's on track with me on it. Not a big deal. Gives me more credibility. He understands that I'm not going to try and hide the ball.
Part of the reason I'm asking is because I've seen situations where it is minor, and in an effort to protect the client's privacy, an attorney will decide not to disclose it or, say it's subject to privilege. That minor thing ends up being a long, long fight and becomes a credibility issue when it would have been a non-issue if you just sent it out.
And I will also add, there are some medical facilities who do not limit your records to time, scope, body parts at issue. Particularly Kaiser, they will just send you a mass PDF file, and it is going to be very lengthy for you to go through and to piecemeal pick out individual doctor's appointments that have nothing to do with the treatment. And then you get a record that is missing 20 or 30 pages at a time. And the opposing attorney is going to sit there and say, there's this large gap in these records. Like, I can take you for your word, but I owe my client a duty to make sure that what I'm being given is correct. And it will create a lengthy, long, drawn out discovery issue that all it's going to do is negatively affect your client. It's going to require more time. It's going to prolong the case and the resolution. It's not beneficial if it's nothing that's going to be a hazard to your client to begin with.
That all makes sense. Going on to completed discovery. So you've put all the answers into your request for production, request for admissions, interrogatories, got the documents all stacked up. How do you get those out to the client for verification and final approval?
So pre-pandemic, we would normally have a client come in and I would be going through everything line by line with them in person. It would probably take 30 to 40 minutes. There are some instances where clients require more time, more hand-holding to go through line by line. And then you have the occasional, I answered this with the information that I was given. This is far from correct. I need to go and make significant changes before we send this out. I'm going to go and do that while you're here and make sure that I have this done the right way. So pre-pandemic, I would normally do it in person with them. After the pandemic, with the myriad of the new e-service rules that we have and being able to email responses back and forth, we'll sit and have a Zoom meeting, or I can email the client the documents in a PDF format, ask them to go through it, tell me if there are any changes that they need to make. I can go through it line by line with them over the phone. As long as I have a good 30, 40 minutes of their time, I can normally kind of roll through it wickety split. It just really depends on how tech savvy they are. If I want to do it via Zoom, share screen, go over it with them on the phone, just kind of depends.
From a importance perspective, from your perspective, why is it important for the client to go through it all and make sure that it's all correct?
One is I am also sending something out with my name on it, as well as my firm's name on it, and I don't want to represent anything incorrect. Two is the clients are going to be signing that the answers that I'm presenting, that I've helped them write and respond to under oath, are correct to the best of their knowledge. So they're going to need to make sure that it's correct because we're testifying under penalty of perjury that these are correct. And this is what I'm representing, and I'm not hiding the ball. I'm not lying. I'm not giving you any bad information.
Is there anything else that you think people should know about how to approach discovery in terms of that initial packet that arrives?
Start early. I oftentimes will try and get ahead of the ball, build that relationship with the client early on, and also get a sense of your client's technological savviness early on. Are they quick to respond to your emails? Are they quick to respond to text messages? Are they quick to respond to your phone calls? Or is this client someone who you are going to have to call 3 times to get a response from? If that's the case, you are going to have to be spending a little bit more time on these responses because you sadly don't know where they went to high school. You don't know what city they were born in. And you are going to need to know that information. Another thing that I think we oftentimes overlook is the invasion of the privacy that a lot of these questions have on the clients. And a lot of these clients, they give a lot of pushback. I was injured in a car accident. Why do you need to know where I went to high school? I was injured and I was hit while I was riding my bike in the middle of a crosswalk. It was not my fault. Why do you need to know where I'm working? And for us, I understand what the questions are relating to. I understand why they're important. The clients don't have a concept of that. And sometimes you have to walk through them and say, yes, I understand. I don't think that where you went to high school is relevant here. However, this is a question. They're allowed to ask it. We need to respond to it. And I'll let you know that the person who hit you, I'm going to be sending them the same question back. And it might not make it okay for them, but it gives them a little bit more of a sense of, okay, if I have to answer this and they have to answer that, I'm okay with it. Sometimes you get a lot of pushback. People don't like people asking questions about their private lives. Sometimes it's hard for people to come and talk about an injury and how it affected their lives. And then you start asking these nitty-gritty questions. Where have you lived for the last 5 years? Why is that relevant? Why is it relevant what city I lived? Another aspect to take into consideration for that, people who are undocumented, people don't want to answer those questions honestly sometimes. And you have to run through that emotional conversation about, that's not a relevant piece of information right here. I need you to trust me. Don't worry about it. We got to answer these questions. I'm here for you. I'm not going to let someone come after you.
That all makes a lot of sense. I think one other thing that I will sometimes communicate with folks is ultimately the people on the other side are human beings, and we're going to be building this into a demand package or a mediation brief or a presentation to a jury. And think about the conversations you have with people when you initially meet them. And those conversations oftentimes involve, where'd you grow up? Where'd you go to high school? Where'd you go to college? What do you do? Where have you lived? And for us as humans to relate to others, to have some understanding of their background, even if it's not relevant to the crash itself, it is relevant to the way people relate to people.
100%.
Well, thank you for being here today, Bryan.
Thank you very much.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions on how you engage with that initial pile of discovery. Like what you've heard, share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.